Hi there.
Hello.
You've got quite the background. Where are you?
I'm in downtown Burlington right now.
Oh.
My associate lawyer, Misha Leslie's getting married tomorrow. It's a small wedding. Sam and I were invited, and so we decided to drive into town the day before so that we could settle in, and we're in the right spirits for his wedding tomorrow.
Well, that's great. It looks like a little, like here it's sunny, but it looks a little like it might rain there. But
yeah, no, it's definitely rainy, almost rainy, overcast. But I am hoping that during this IG Live, I do not get rained on. I thought it would be a nice background for us to have some serenity during what we normally do, which is to talk about fairly stressful events.
Yes. Well, otherwise we'll have to watch you do a rain dance or something. So
that's good.
Now I know we were kind of chatting about what our topic was this week, and my recollection was we were kind of continuing off of last week's live, where we were discussing that case last week where the Chicago case where the mother had been, because of she wasn't vaccinated, the judge had said she couldn't have access to her child. And we had talked about the issue of interim orders and the effects of interim orders in matters. And we never really kind of got fully into that topic. So I think we were doing like continuation of that.
So just for those viewers that were watching us last week, the sequel to the story that we started of the mother who temporarily lost guardianship and custody of her children because she refused the COVID vaccination. The sequel is that judge has reversed his decision and rescinded his order restricting mother's parenting time because of her choice not to be vaccinated. He was provided with more information with respect to the circumstances, specifically her medical situation, and so that story became a non-story very quickly. But the discussion still is a fairly healthy discussion in that there will be stories about people claiming that someone who can be vaccinated is choosing not to be vaccinated poses a risk to children. So that's the sort of wrap-up of that conversation. Now, today's topic is actually a very interesting one. People don't realize this when they start a court case, but most court cases don't make it to trial. In fact, statistically speaking, only about 5% of the cases that started make it all the way to a trial. And that's because in most jurisdictions like Ontario and Canada, the judges have created very deliberate obstacles that would permit a person to actually have a divorce trial. And the obstacles include multiple conferencing with judges. And just by virtue of the actual language of the rules, people have to do a case conference, then a settlement conference, then a trial management conference, and that's just 3. Sometimes they have more than one of that same one. So you might have 3 case conferences before you get to a settlement conference, and you might have 2 trial management conferences. So the bottom line is the court system is based on deliberately creating barriers to trial, and the purpose is, quite frankly, not only morally correct, it's financially correct in that we want people to settle their cases. So enter the subject of interim motions, or another way of calling it is an interlocutory hearing. Basically, it's a hearing that is early in the case, well before the case really unfolds. Interim motions result in temporary orders. Those temporary orders sometimes form the basis of what ultimately will become a settlement. So I'm going to ask you, Leanne, give us an example of where the parties didn't agree on something and they go before a judge on a motion, and the judge either says something, does something, or orders something that then becomes the benchmark for settlement.
Well, one example would be the parenting schedule. Sometimes there's situations where the parties are, very early on, they're not in agreement on what that schedule should be. And so one party brings an interim motion asking for the schedule to be a certain way, and the other party, responds with their position on what the schedule should look like. And the judge at a motion will make a ruling, and that ends up setting up a schedule that, often forms the status quo. And, because it takes so long for matters to move through the family court system, that often, by the time, if you were to take it to trial, that could be a year, 2 years, more than that in some cases down the road. And so this interim parenting schedule that's been set up, has become a new status quo, has become a new normal for the children, and it can often be very difficult to dislodge that, down the road at a trial.
That's right. And so the takeaway for our viewers is that orders that judges make early on in a case on what is otherwise considered a temporary motion, an order that's made just for the purposes of a holding order until more events in the case occur or possibly to a trial, oftentimes become the trial decision. Not because it really is a trial decision, but because it actually creates an impression on the parties, on the lawyers, and on future judges who read what an earlier judge ruled originally. One thing, family law and family court judges are great on many levels, but one of their more common traits is that there is significant solidarity between family court judges. You rarely find a family court judge that will ever say, well, the previous judge made a mistake, or the previous judge didn't have all the information, or I'm ruling differently because the other judge didn't get it right. Even if the earlier decision was an incorrect decision based on an absence of information or a misunderstanding of the information, there is significant loyalty between the judges with respect to decision making. And we lawyers know that. And so I'm going to give you an example of the impact of a temporary motion. I had a case, I've had many of these similar cases, but I'm going to mention one. Just days before COVID, my father client came home from work to find the house empty. The children were gone, his wife was gone, and a note was left that she moved out. Now, this is not the first time this has happened, and when it does, clients have two options. Do nothing and just accept it and negotiate from there, or go to court on what is called an emergency motion and argue that this should never have happened this way. The odd time, clients make the second choice because it's expensive, it's risky, it requires a snap decision. And so in this case, the client gave me those instructions and I rushed off to court. I prepared materials, worked through the night, and got to court on an emergency motion. Happened to be the day before everything shut down. It was March 16, 2020.
Wow.
And I got the client an order where the children were with him 50% of the time. And here we are 18 months later, and that is the status quo. Now, had that father made the decision to not fight it, he might have had the kids every other weekend from Friday to Saturday. He might have had the kids on Saturdays only. It would have been a very different outcome. But that was an example of where a temporary order was made on a motion and had long-term effects. Another example is where the parties cannot agree on how much support should be paid. And one says, well, I'm self-employed, I only earn $50,000. The other one says, that's hogwash. He's self-employed and he earns $150,000. Well, you go to court on an interim motion, and a judge says, you know what? I'm going to order it based on an income of $120,000. Well, Mr. $50,000 didn't get what he wanted. Ms. $150,000 didn't get what she wanted. But the judge on the motion made an order based on support of $120,000 of income. And now they live with that for 1 month, 2 months, 6 months, 12 months, a year and a half. And then the question becomes, how are they going to settle this case? Well, They can go to court, they can go to trial and spend $50,000 to $100,000 arguing that the income is either 50 or 150 or some other number, or they can just simply accept a settlement on the basis of the 120. And that happens all the time. So the purpose of this IG Live was to talk about the role of motions and interim orders on final settlements. And Leanne, do you have any other stories that you could share on where your motion outcomes did have an effect on the final settlement?
Yes, going back, I seem to have a lot of these where they're to do with custody or what we call decision making now and parenting plans. But I had one where I had a client and he and his wife had an infant, basically like an 18-month-old child, and mom was dad was my client, so mom was taking the position that the child shouldn't have any overnights with dad at all. And we brought an interim motion, and the judge awarded dad 2 nights for a period of time, and then it was going to graduate as the child adjusted to that. And he was thrilled because he wasn't being given any overnight time at all. And then once that ruling was made, mom kind of more quickly fell into line with it and seemed more open to some form of a shared parenting arrangement that she was not open to at all before that happened. So that they were eventually able to settle on that issue, but it was largely because of what had happened on the motion.
Yeah. One last thing I want to talk about with our viewers is the other impact of interim rulings. Now, remember that people that go to court are people that are splitting up. And the people that are splitting up that do go to court are people that really were unable to agree on an outcome without going to court. So let's back it up. We've got a couple that's splitting up. We've got a couple that's splitting up that cannot even resolve their affairs with lawyers, possibly without even, they can't even resolve their affairs with mediators. So they made the decision to go to court. And now, just because you go to court doesn't mean you have to have hearings. Like I said a few minutes ago, most of the cases that go to court end up getting resolved at or around conferences. So the ones that actually make their way to a contested hearing are already the more conflictual ones within the arena of conflict cases. So now, within this very narrow population of cases, they go to court because A and B don't agree. And then an outcome is made, like the one that you just mentioned, Leanne. The client was not comfortable with the overnights, and a judge ordered overnights. Now, the client has the option to appeal, although most of us recognize that orders made on motions rarely ever get appealed, and if they get appealed, they don't get overturned. But putting all that aside, the person that suffers a loss on a motion is now gun shy to go back before court to get another order on something else. They've already been burned once. The other side of that is the person that went to court on a motion and got what they wanted. They got a taste of what it's like to have their day in court prevail. And so that affects the psychology of the two people. The loser on a motion is very much deflated. The winner on a motion is very much inflated. Mm-hmm. And that also affects the bargaining positions of the two people in the weeks and the months that follow.
And one part of that as well is that, as a lot of our listeners may be aware, that legal costs can factor into this. Because often if you're successful on a motion, you may be able to recover some or most of your legal costs, depending on the circumstances. And of course, if you lose the motion, alternatively, you may have to pay not only your own legal costs, but your ex's legal costs are a portion of them as well. And that can be a really bitter pill to swallow for the person who's already upset that they lost the motion, but now they also have to pay those legal fees for their ex on top of it. And so playing into the psychology you just described, Steve, I think that makes the loser on the motion even more gun shy, having to do that. And it is a bitter pill for most people to swallow. They're already upset enough about paying their own legal fees, let alone their ex's. And I do think as well, it has that effect of inflating the winner even more, because it makes them feel quite happy with themselves to see that their ex had to also pay some of their legal fees, or most of them. And so they're not feeling the cost or the bite of the legal fees involved with having, to gone to court or being more litigious to begin with.
And it's funny you use the word bitter pill. The notion of pills is something normally within the sphere of medicine and healthcare. But when you think about judges also having to diagnose and solve a problem, they actually are very deliberate with what you've described, Leanne, when it comes to ordering costs. Many judges recognize that by clobbering somebody on costs, they are actually foreshadowing the resolution of their case, because by making a decision on temporary parenting, temporary support, sale of a home, what school children should go to, whether people should be vaccinated or not, when judges make a decision on these interim motions, which are supposed to be sort of just short-term decisions, bridging them to a later date, we all have now come to recognize that it's not exactly a short-term decision bridging us to a later date. It is ultimately going to be the very thing that brings this case to a crashing end. So when a judge orders A to pay B, costs of a motion of $5,000 or $10,000 or $20,000, they know that by the more bitter the pill, the more likely this case will not come back to court, because people will solve it without them returning. And so that's why I am very careful when it comes to choosing which cases to take before a judge on an interim motion. And I'm very careful when advising a client to not cause them to take the risk of letting a judge flip the pen and make a quick decision that may not go the right way, and therefore inflate the other side's head, cause my client to incur unnecessary costs, and then lose what is otherwise strong bargaining position that they would otherwise have at mediation or otherwise.
No, it's very important, that clients understand that. And as you said, Steve, that we only argue, a motion when it's really, really warranted because of the risk involved. And, sometimes on some of these urgent motions as well, if your client gets served with one of them and you've got a short turnaround time to get the materials out, and the judge is, largely looking and relying on those materials, the judge may not have the full picture because of, the shortness of time and having to get things together. They're not going to likely have, an affidavit from an expert that might have been helpful to do a child development or some particular, challenge that the child is struggling with developmentally or whatever it might be. And so you have judges making decisions that not on a complete fulsome picture, and it's it's in a backlogged court where you're lucky to get a long motion. You're looking at, like right now, you would be looking at dates well into 2022. But even for a shorter motion that's an hour or two, the dates are hard to get. So you want to be careful with that, because it is.
And in fact, I don't know if you know this, but in Brampton they have a new practice direction. You're only allowed one motion
per file.
Yeah. So think about it. If you've got 3 pressing issues, the kids are being pulled out of one school, taken to another, the mortgage is in default because one person isn't paying the bills and one person is putting the children at risk by, for example, not getting vaccinated. Now you got to choose which emergency are you going to choose.
Yeah.
You can't choose all three. You can only choose one.
But, and I think that's a good thing, because I mean, recently I posted about litigation abuse, and I think it is very real. There has been a history, you know, with some parties of, you know, bringing motion after motion, and trying to exhaust the other party's financial resources, by, you know, being frivolous in their litigation, or just constantly delaying things. So I think that perhaps allowing parties only one motion, you know, is a step in dealing with that particular issue.
And even on those motions, the judges have now come down real hard on how long your affidavit could be.
Yeah.
So it's almost like watching the prime ministerial debate last night. Just as each question was being answered, the moderator cut that person off and went to the next person. No question could ever be answered. Similarly, with these motions, you get very limited time. You get very limited space in your affidavit to really articulate your case. The decision is often made on a snap basis, but it has long-term effects, and it significantly alters the bargaining position of each side. So to bring it to a close, these motions in family court are really important, and they need to be carefully thought out, whether you're the moving party or the responding party, and you've got to do a really good job figuring out how to use a motion to move the needle in the direction of settlement. Because if you miss that opportunity, if you make a mistake, it could fundamentally alter the future relationship between parents and children and the future financial arrangements in a divorce settlement. So make no mistake, these motions are brutally strategic in mind. And you need to think about how they play a role in the overall development of your divorce settlement.
Well said. So I think we should wind things up on that note. So thanks, Steve, for joining us from Burlington.
And bye from Burlington.
And thanks to our listeners. We'll see you next week.
You got it. Bye-bye.
Bye.